As we are continuing with our chapter number 10, I share it on the screen. From the beginning, there were, strong differences of opinions relating to the right to privacy. Members like B.N. Rao, A.K. Ariyar, and M.K. Panikar had a strong objections to the right to privacy being elevated to the status of fundamental right. The most open criticism of right to privacy was done by the Aladi Krishnaswamy Iyer and B.N. Rao, who were members of the Constituent Assembly. Comments of both of the members show their resentment towards the right to privacy. Iyer, through the granting of right to privacy and secrecy in correspondence, would be disastrous. It would be, private or civil communication to that of the state papers. This would adversely affect the civil litigation where the documents form an essential part of evidence. B.N. Rao was primarily concerned with the interference of right to privacy with the investigative powers of police authority. Later on, both Rao and Iyer were successful in persuading the advisory committee to leave out the provisions relating to the right to privacy. During the ongoing sessions of the Constituent Assembly, there has been a couple of times when an endeavor was made to include the right to privacy within the chapters of fundamental rights. On April 30th, 1947, one of the members of Constituent Assembly, Somnath Lahiri, presented a proposal to make the right to privacy a correspondence to fundamental right. The privacy of correspondence should be inviolable and may be infringed only in case provided by the law. However, this proposal failed to get a positive response in the Assembly. Against or after almost a year, another attempt was made by Qazi Sayyid Karimuddin on December 1948 to incorporate the right of people to be secure in their persons. Houses, papers, effects against the unreasonable searches and seizures shall not be violated, and no warrant shall be issued, but probably cause supported by an oath or affirmations, and particularly describing the place to search the persons or things to be seized. Now, the Indian Constitution failed to recognize the right to privacy as a part of fundamental rights to be conferred on the citizens of India. But over some time, none of them, Supreme Court of India, has played an important role in addressing the several cases that have dealt with the right to privacy in some form or other. And they have helped the right to privacy attain its rightful position as a part of right to life and liberty under Article 21. In one of the earliest cases, MP Sharma and Satish Chandra, where the Supreme Court addresses the issue of the power of search and seizure, it held that the privacy could not be brought under the umbrella of the fundamental right as it was something not related to Indian Constitution. It was seen that the Supreme Court had narrow interpretation in this case, limiting itself only to the prescribed statutory regulation. A decade later, there was another important case that was Kharak Singh versus State of UP that dealt with the issuance of the surveillance, whether the surveillance which was defined in the Regulation 236 of the UP Police Act led to the infringement of fundamental right or not. The verdict that was given by the Supreme Court denied the right to privacy was a fundamental right and it was not guaranteed under our constitution. And therefore, the attempt to ascertain the movements of an individual merely in way in which the privacy invaded is not an infringement of fundamental right guaranteed under the Part 3 of the Indian Constitution. And it is, however, held that Article 21 was repository of residual personal rights and recognized the common law right to privacy. Now, however, in this case, Justice Subbarao did say that privacy is a facet of the liberty. Now, the next case of Govind versus State of MP, even though this case was similar to that of Kharak Singh, the approach to this case was very much different. It was upheld the validity of the Madhya Pradesh Police Regulation Act 1961, subject to the reasonable restriction. The judicial approach was there in the existence of the right to privacy in terms of different guarantees provided by the Part 3 of the Indian Constitution. However, the Supreme Court also observed that in absence of the legislative enactment, the right to privacy will necessarily have to go through case by case development because just one single case will not be sufficient to see the exceptions and consequences of right to privacy, but one cannot deny the fact that this case did broaden the scope of Article 21 so that the right of privacy could fall under it. Now, in case of 18 Jabalpur Shivakant Shukla, the Supreme Court wanted to determine whether the right to personal liberty is restricted by any restrictions other than those that are contained in Constitution, statute, law, and established that the right to privacy may not be expressly guaranteed may be implicit due to its inclusion in common law. Justice Khanna had observed that the Article 21 is not the rule repository of the right to personal liberty. No one shall be deprived of his life or personal liberty without the authority of law, and this authority flow not merely by the common law but equally from statutory law like the penal laws in force in India. Then it was the Menka Gandhi versus Union of India, where the Supreme Court, in a broader sense, interpreted Article 21. The Supreme Court of stated that the term natural law, which includes the right to personal liberty and rights of personal security, was incorporated in Article 21 of Indian Constitution. Rajgopal versus State of Tamil Nadu was one of the first cases that elaborated of the development and scope of right to privacy in a detailed manner. The apex force has held that the right to privacy was implicit in the rights to life and liberty in Article 21 guaranteed. In further recognized that a citizen has the right to safeguard the privacy of his own, his family, his marriage and procreation, motherhood, childbearing, and education, among others. No one can publish anything concerning the above without any consent, and the right to privacy can both be actionable and fundamental right. Now, Unique Identification Authority of India and the CBI. This was a case that involved the Central Bureau of Investigation, which sought to access a huge database that has been complied by the Unique Identity Authority of India for investigative purpose and regarding the criminal offense. However, the Supreme Court said that the UIDAI should not be transferred by any biometric information about anyone who has been allotted an Aadhaar number without written consent of the persons, uh, you know, shall be deprived of any kind of service for the want of an Aadhaar card in case where he or she is otherwise eligible or entitled. The various authorities would have to modify their circular forms so that the compulsory requirement of Aadhaar card is not required to meet the requirements of interim order passed by the court forthwith. Justice K.S. Puttaswamy retired and another versus Union of India. The verdict was the outcome of petition challenging the constitutional validity of Indian biometric identity system. Aadhaar. This was a case relating to the unique identification scheme that was discussed along with the right to privacy. The question that was placed before the court was whether a right like the right to privacy was guaranteed under the constitution or not. The Attorney General of India, however, argued the privacy did not have the place in fundamental right guaranteed to Indian citizens should be left to be discussed on a large constitutional basis because of those judgments that denied the existence of the right to privacy was accepted as a fundamental right. Due to this, an unresolved controversy emerged which compelled the court to refer this issue to a larger bench so that it could be settled. The unanimous judgment by the Supreme Court of India and Justice K.S. Puttaswamy versus Union of India is resounding victory for privacy. The order signed by all nine judges declared that the right to privacy is protected as an intrinsic part of right to life, personal liberty in Article 21 and as a part of freedom guaranteed by Part 3 of the Constitution. Now, finally, in August 24th, 2017, a historical judgment was made by Supreme Court of India that stated that the right to privacy is a part of fundamental rights and were to be protected by Indian Constitution. The Supreme Court declared that the right to privacy stems from the fundamental rights to life and liberty, and it would have a long-lasting consequence. The nine judges bench of the Supreme Court is involved in case of Puttaswamy versus Union of India, which declared the right to privacy to be protected under Article Part 5 or Part 3 of the Constitution. The judgment was in response to the reference made in connections with the challenges to India's national integrity project for Aadhaar card. Right to privacy in cyber world. Hacking into someone's private properties or stealing someone's intellectual work is a complete violation of his right to privacy. The Indian Constitution does not specifically provide right to privacy as one of the fundamental rights guaranteed to Indian citizens, but it is protected under the IPC. Cyberspace is a non-physical terrain created by computer. Most often than not, in the recent times, citizens, also known as the netizens, have been increasingly, making the use of cyberspace to seclude themselves from their social circle. There is a generalized belief that the people are private and want to secure their privacy. In reality, it turns out to be their serious threat of infringement on privacy of individual in cyberspace. To recognize the digital evidence and electronic record, the Information Technology Act came into force on and before October 17, 2000. The preamble of the act was read as follows: an act to provide legal recognition for transactions carried out using electronic data interchange and other means of electronic communication, commonly referred to as electronic commerce, which involves the use of alternatives to paper based methods of communications and the storage of information to facilitate the electronic filing of documents with the government agencies, and further to amend the Indian Penal Code, the Indian Evidence Act, and the Bankers Book Evidence, Reserve Bank of India 1934, for the matters connected with or incidental thereto. The Act also recognizes a new form of cybercrime and provides punishment for the same. Now, the cybercrime made punishments under the Act are set as Section 65 to 85. Now, the punishments prescribed there under the ranges from the imprisonment up to 3 years to imprisonment for life, and any fine, amount could be imposed. An upper limit ranging from 1 lakh to 5 lakh is also prescribed. Cybercrime is an evolving field, therefore, with the changing times, more or more crimes emerges from the violations committed in cyberspace are detected. The common forms of cybercrimes have been broadly categorized into the cybercrimes against the people and cybercrimes against the property. The right to privacy is an important, a natural need of every human being, as it creates boundaries around the individuals where the other people entry is restricted. The right to privacy prohibits interference with or intrusion into another person's right. The Apex Code of India has affirmed its judicial pronouncement that the right to privacy is very much part of the fundamental right of Article 21 of Indian Constitution. Thus, the right to privacy comes under the, comes under the uh, extend ambit of Article 21 of Indian Constitution. So whenever some cybercrime is related to person's private property or personal stuff, the accused can be charged with a violation of Article 21 of Indian Constitution, and prescribed and remedy can be invoked against the accused. Now, if when we proceed to the legislations about the digital communication as only handful, already the Information Technology Act, you know, uh, in this regard, in Indian Telegraph, which governs the use of wired and the wireless telegraphic telephones, teletypes and radios, communication and digital data communication, it gives the government of India exclusive jurisdictions and privilege for establishing, maintaining, and operating licenses and overseeing all forms of wired and wireless communication within Indian territory. It also authorizes the government law enforcement agencies to monitor or intercept communications and tap phone lines under the conditions defined under the Indian Constitution. The Act came into force in October 1885. Since the time, the numerous amendments have been passed to update the Act to respond to the changes in technology. Now, the Commercial Communication Customer Preference Regulations is one of the pieces of the regulation that prevents the service provider from the arbitrary sharing the personal information. Thus, all the service providers have to take necessary measures to protect the privacy and information shared on their system. I'm bringing the course back on the screen. The telecommunication Commercial Communication Customer Preference Regulations 2020 is one of the important piece of regulation that prevents service provider from arbitrarily sharing the personal information. Supreme Court has also dealt with the right to privacy in context of interceptions of the phone calls in case of Amersing versus Union of India. The question of whether the interceptions of telephone messages or tapping of the telephone conversation constitutes a serious invasion of individuals' right to privacy was considered in detail by the Honorable Apex Court and People's Union, wherein it was held as under. We have therefore no hesitations holding the right to privacy as a part of right to life and personal liberty enshrined under Article 21 of the Constitution. Once the fact is given, case constitutes a right to privacy, Article 21 is triggered. The said right cannot be curtailed except according to the procedure established by law. The right to privacy by itself has not been identified under the Constitution. As a concept, it may be too broad and moralistic to define it judicially. Whether the right to privacy can be claimed or have been infringed in each case would depend on the fact of the set case. But the right to hold a telephonic conversation in privacy of one's home or office without interference can certainly be claimed as right to privacy. Conversations on the telephones are often of an intimate and confidential nature. Hence, a telephone conversation is a part of modern men's life. It is considered as an important, and more people are carrying mobile telephone instruments in their pockets. Now, this is also inclusive of Article 21. This is also telephone tapping is also infringement of Article 21 unless it is prescribed in certain procedure of the law. Right to data protection. The strongest legal protection provided to personal information in India is through Section 43 of the Information Technology Act. The Information Technology Reasonable Security Practices and Procedure in Sensitive Personal Data or Information Rule 2011 developed under the section. Now, data protection laws in India. The data protection refers to the set of privacy laws, policies, and procedures that aims to minimize the intrusion into one's privacy caused by the collection, storage, and dissemination of the personal data. The personal data generally refers to the information of data that relates to the person who can be identified from the information or data, whether collected by any government, private organization, or agency. The Constitution of India does not expressly grant the fundamental rights to privacy. However, the court has read the right to privacy into another existing fundamental freedom of speech and expression under Article 19, Clause 1. The right to life and personal liberty under Article 21 of Constitution of India. However, these fundamental rights under Constitution of India are subject to reasonable restrictions given under Article 19 of 2 of the Constitution. They may be imposed by the state. Recently, in the landmark case of Justice K. Puttaswamy, Union of India, the Constitution bench of the Union, Honorable Supreme Court held that the right to privacy to be fundamental right subject to certain reasonable restrictions. India presently does not have express legislation governing the data protection of privacy. However, relevant law to the India dealing with the data protection of IT Act, the Contract Act of 1872. A codified law on the data protection was introduced, and this was known as Information Technology Act 2000, that deals with the issues relating to the payment of compensation, civil and criminal, in case of the wrongful disclosure and misuse of personal data and violation of contractual terms and concerning the personal data. The Section 43 of the Information Technology Act, a body of corporate that is possessing, deals with, handles any sensitive personal data or information that is negligent in implementing and maintaining reasonable security practices resulting in wrong loss or wrongful gain in any person may be held liable to pay damages to the person so affected. It is important to note that there is no upper limit specified for the compensation that can be claimed by the affected parties in such circumstances. The government has notified the information technology, reasonable security practices and procedures in sensitive personal data or information. The rules only deals with the protection of the sensitive personal data or information of person, which includes such personal information that consists the password, the financial information of banks and the credit cards, the psychological mental health conditions, the orientations, the medical records, the biometric information, etc. Now the rules provides the reasonable security practices and procedures that the body corporate of any person who, on behalf of the body corporate, collects, receives, and possesses, stores, deals with, or handles information is required to follow when dealing with the personally sensitive information. In case of any breach or the body corporate or any person acting on behalf of the body corporate may be liable to pay damages to the persons so affected. Under Section 72 of Information Technology Act, the disclosure of information knowingly and intentionally without the consent of the person concerned is the breach of lawful contract has also been made punishable with the imprisonment of a term extending to the 3 years and a fine extending to 5 lakhs. It is also noted that Section 69 of the Act, which is exception to the general rule of maintaining privacy and secrecy of information, provides that where the government is satisfied that is not necessary for the interest of the sovereign or integrity of India, defense of the state, the security of state, the parental relation with the foreign state, public order for preventing the incitements and incitements to the commission of cognizable offense or for the investigation of any offense. If may or by order direct any agency or the appropriate government to intercept, monitor, decrypt, or cause to intercept, monitor, or decrypt any information generated, transmitted, received, or stored in any computer resource, this section empowers the government to intercept, monitor, or decrypt any information, including the information to a person's nature or any computer resource. Where the information is such that it is ought to be divulged by the public interest, the government may require disclosure of such information. Now, going to the next slide is the Information Technology Act 2000. The Information Technology Act 2000 is an act to provide the legal recognition of transactions carried out by utilizing electronic data interchange and other means of electronic communication, commonly referred to as the electronic commerce, which involves the use of an alternative to paper-based methodology of the communication storage of information to facilitate electronic filing of documents with the government agencies, the grounds on which the government can interfere with the data. Under Section 69 of the IT Act, and any person authorized by the government or any of its officers specifically authorized by the government, if satisfied it is necessary or expedient to do so in interest of the sovereign or integrity of India, defense of the state, security of the state, friendly relation of the foreign state or public order, or for preventing the incitement to the commission of an cognizable offense relating to above or investigation of any offense for the reason to be recorded in writing or order for direct or any agencies of government to intercept, monitor, or decrypt or cause to be any information generated, transmitted, received, or stored in any computer resource. The scope of Section 69 of the IT Act includes both interception and monitoring, along with the decryption to the investigative cybercrime. The government has also notified the information technology procedures and safeguards for interception, monitoring, and decryption of information under the above Act. Now, the penalty for damages to computer systems, etc. under this Act. Section 43 of the IT Act imposes a penalty without prescribing any upper limit for doing any of the following act. Access or the, uh, access to the computers, computer systems, or computer network, downloading the copies or extracts any data, computer data or information from such computer system or computer network, including information or data held or stored in any removable storage medium, introduces or causes to be introduced any computer contaminant or computer viruses into the computer system or computer network, or damages or causes to be damaged any computer system or computer network or any other program residing to such a computer or computer network, disrupts or causes disruption in computer network, denies access to the person or the charges the service availed by a person in the account of another person by tampering with or manipulating any computer system in the process. He shall be liable to pay damages. Now, destroys, deletes, or alters any information residing in a computer resource, diminishes its value or utility, or affects it injuriously by any means, steals, conceals, destroys, modifies, or causes any person to steal, conceals, destroy, or modify any computer source system used for a computer resource with the intent to cause harm. Now, as we can see, tampering with the computer source document is provided under the IT Act 2000. Section 65 of the IT Act lays down that whosoever knowingly or intentionally conceals, destroys, or alters any computer resource system or computer program, computer system, or computer network when the computer source code is required to be kept or maintained while law for that time being enforced shall be punishable with imprisonment up to 3 years or with a fine that may extend to 2 lakh rupees or with both. Now, computer related offense. Section 66 provides that if any person dishonestly or fraudulently does not act referred to at Section 43, he shall be punishable with imprisonment for a term which may extend to 3 years or with a fine of up to 5 lakh. Now, penalty for the breach of confidentiality and privacy. Now, Section 72 of the IT Act provides for the penalties of the breaches of confidentiality and privacy. The section provides that the person who, in pursuance of any power conferred by the IT Act, rules or regulations made thereunder, secures access to the electronic record book, register, correspondence, information, documents, or any material without consent of person concerned, documents or any material without the consent of the person concerned, discloses such material shall be punishable for 2 years and up to 10 lakh rupees of fine. Now, the amendment of Section 10A was given to the IT Act, and this, following important sections have been substituted in 2008 amendment. Section 43A is the compensation for failures to protect. 66 is computer related offense. 66A has been repealed by the Shreya Singhal case. 66B, punishment for dishonestly receiving a stolen computer resource or computer device. 66C, punishment for identity theft. 66D, punishment for cheating by personation. 66C, punishment for violation of privacy. Then 66F is punishment for cyber terrorism. 67 is transmitting the obscene material. 67A is publishing or transmitting sexually explicit acts in electronic form. 67B is any material depicting children in such explicit act. 67C is preservation and retention of information by intermediaries, as we have discussed. 69 is power to issue direction for interception, monitoring, or decryption of any information through computer system. 69A is power to issue directions for blocking public access to the information through any computer resource. 69B is power to authorize monitoring, collecting traffic data, or information through the computer system for cybersecurity. Punishment for disclosure of information in breach of lawful contract. Now, exemptions from the liability of an intermediary in certain cases. Modes or methods of encryption. Now, Section 84B, punishment for the abatement of offense, punishment for the abatement to commit an offense. Right to information. Cyberspace is a rapidly growing network of computing and communication technology that have profoundly altered by our lives, and we already carry out myriad social, economic, and political transactions through the cyberspace. And as the technology moves, so we will so the quality and the quantity. But the very technology that enables the transactions also make detailed, cumulative, and invisible observations of ourselves possible. Now, the potential for the wide-ranging surveillance of all our cybersecurity presents a serious threat to the information privacy. The private sector seeks to exploit this data commercially and primarily for the data marketing issues, but many individuals resist. The dominant approach to resolve this problem is to view personal information as to a commodity that interested parties should contract for in the course of negotiating in cyberspace. But this approach has so far failed to address a critical question: which default rules should govern the flow of personal information when parties do not explicitly contract about the privacy? Justice K.S. Puttaswamy, Union of India, to make this right meaningful in the state, must put a place of data protection framework which, while protecting citizens from dangers to information privacy originating from the state and the non-state actors, serves the common good. It is the understanding of the state's duty that the committee must work while creating a data protection framework. Now, privacy itself was held as a, in Puttaswamy case, the Supreme Court held that the right of privacy is a fundamental right and flowing from the right to life and personal liberty, as well as the fundamental right securing the individual liberty to constitution. The privacy right has held to be a negative aspect. The right to be let alone, a positive aspect, right to self-development. The sphere of privacy includes a right to protect one's identity. The right recognizes the fact that all informations about a person in fundamentally her own, and she is free to communicate or to retain it herself. The core of information privacy, thus, it is the right to autonomy, self-determination, and respect of one's data. The court observed in the following: the formulation of regime for the data protections in complex exercise which needs to be undertaken by the state after a careful balancing of the requirement of privacy coupled with the other values of protections by the data subserved together with the legitimate concerns of state. Now, the right to RTI amendment. The committee recommends that the amendment under Section 8(1) of the J of the RTI Act, which pertains to the disclosure of the personal information of large public interest. There would be no obligations to reveal the personal information which was not related to public authority or interest or would be invasion of privacy. The new Section 8(J), looking at a balancing act between the public interest in accessing the information on one hand and the harm that caused to the data principle on the other. Now the test is when the personal information can be revealed through RTI. As we are going to conclude our chapter with this, the court observed that the harm to individual or public interest. Now, this is the Thapalam Service Cooperative Bank Limited versus State of Kerala. The two judges, when consider the correctness of the decision of the Kerala High Court, which upheld a circular issued by the Registrar of Cooperative Societies, by the circular, all cooperative societies were declared to be public authorities within the meaning of Section 2 of the RTI Act 2005. Section 8(1) Clause J contains an exemption from the disclosure of personal information which has no relationship to any public activity or interest or which would cause an unwarranted invasion by the privacy of individual unless the authority is satisfied that a large public interest justifies its disclosure. The court observed that the right to privacy has been recognized as a part of Article 21 of Constitution, and the statutory provision contained in Section 8J of the RTI Act have been enacted by the legislation in recognition by the constitutional protection of privacy. The court held that the right to privacy is not expressively guaranteed under the Constitution of India. However, the Privacy Bill 2011 is to provide for the right to privacy to citizens of India and to regulate collections, maintenance, and dissemination of their personal information for penalization for violation of such rights and matters contained thereof. In various judgments, the Supreme Court of India has recognized the right to privacy as a fundamental right and invalidating the right Article 21 of the Constitution. Referring to the judgment of Constitutional Court of South Africa in NM and Smith and others in 2007, had this to say about the fundamental right to privacy recognized by the South African Constitution. An implicit part of this, aspect of privacy is the right to choose what personal information of others is released into the public space. The more intimate that information, the more important in its fostering privacy, dignity, and autonomy that an individual makes the privacy decision whether to release the information or not. The decision should not be made by other person. This aspect of right to privacy must be respected by all or not only the state. Now, recognizing the fact that the right to privacy is a sacrosanct facet of Article 21 of Constitution, the legislation has given efforts safeguards to protect the right. Now, under Section 8G of the RTI Act, if the information sought to the person has no relationship with the public authority or officer concerned, is not legally obliged to provide the information. Now, Girish Ramchandra Deshpande was a Central Information Commissioner, wherein the court has held that since there is no bona fide public interest in seeking the information, the disclosure of the said information would cause an unwarranted invasion of privacy of the individuals in Section 8(1)(j) of the RTI Act. Further, if the authority finds the information sought can be made available in large public interest, then the officers should record his reasons in writing before providing the information. Now, to conclude with it, the right to privacy had no place in the Indian Constitution in the start, but now it has been recognized as a fundamental right. With the time evolution of the right took place with the precedents and judgments, and now has a unique place in Constitution. It also found that everyone's accessing cyberspace ought to have a better, informations, and they should be informed about the advantages and disadvantages using the same. The law concerning right to privacy in cyberspace is still in the nascent stage, and therefore individuals have a key role to ensure that the right to privacy are not intruded upon the due to ignorance. So that's the end of our chapter. And in the next slide, we are going to proceed to our next chapter.